Good morning, Mr. Gwagwa.
Good morning, CJ.
How are you?
I'm blessed and you?
I'm fine, thank you.
Thank you.
Are you ready to start?
Yes.
As ready as can be.
Yes.
All right. That's
Yes.
good enough.
All right.
You have two law degrees, a BUris and LLB, obtained from Walter Sisulu University.
That's correct, CJ.
Right.
That's correct.
But obtained when it was still the University of Transkei.
Yes, it was the University of Transkei. You always say humble. You always honor the humble beginnings.
Yes.
Those were my humble beginnings.
Indeed.
Yes.
You have also undergone other training, though. What else have you? You have a. Is it a certificate in dispute resolution in labor matters? Is the
Yes.
diploma? What is it exactly?
Yes. I attended a course of labor dispute. I think it was in Devon. Yes. So it was just an attendance.
Oh, I see. And you've also undergone the aspirant judges training program.
Yes, I think that was last year.
More
January.
recently, yeah. In January 2024, your application form says.
Yes, I did attend that aspirant judges course. Yes. I
Okay.
think for a week.
Okay. You're an attorney
Yes, an attorney. I was admitted somewhere
in 1995.
1998,
Oh,
November.
you did articles in 1995, 96.
Yes. I
Then-
started at Pierre Gachun,
Yes.
Ikopo, and then I went to Pietermaritzburg. I studied articles to Pietermaritzburg at AM Malizo. Malizo, you'll remember, he was a judge as well at KZN.
I remember him.
Yes, so he was my principal.
Oh, I see.
Yes.
And you have practiced and
Sorry, Chief Justice. I wonder if the candidate could put the microphone next to his.
Oh.
I'm struggling to hear.
just bring your mic closer to you. We don't have very good sound equipment here.
Okay, my voice is very low, so I'll try and raise it.
That's better.
Yes.
You are currently a managing director in your own firm,
Yes, MS Gwagwa Associates.
which you started in 2000 already.
Yes, correct, CJ.
All right. You've had various acting stints in the High Court.
Yes, I started in October 2023. Yes.
And how many terms? have
I think if you combine all the weeks, I think it's 29 weeks,
you? 29
which
weeks.
is equivalent to 6 months to 2 weeks.
All right. And all these acting stints were in
And
both Devon and Maritzburg.
Devon and Pietermaritzburg.
Okay. And how have you found that experience?
Very interesting, and it was, a good exposure. I did not expect to be given such an opportunity. However, I grabbed it by both hands, and I dedicated myself and said, look, let me be a servant, serve the nation and serve judiciary at the best that I can. So it was beautiful. It was awesome.
What kind of practice do you run? Is it general practice?
Commercial work, I deal with most municipal work. I've been on the panel for various municipalities. So I do a lot of work for municipalities. So, like
And RAF work as well, according to your form. Road accident fund work.
come against it, can I?
Road accident fund work.
Yes.
That's what you call it.
Yes, I do road.
Medical negligence
Exactly, yeah.
lawsuits.
Yes, I'm on the panel currently with the KZN MEC Department of Health.
And what kind of cases have you been exposed to during your acting stints? Has it been the whole gamut?
During my acting stint,
Uh-huh.
civil, you will find the applications for sequestrations as well as provisional sequestration. I got an experience there to deal with those matters, which deals with insolvency, So I dealt with those matters, extensively. So
You've sat in motion court, opposed, unopposed.
Opposed matters and unopposed, you will get your divorce matters, you will get your application for mortgage bond, to declare them executable. So you'll get a variety of matters,
You've conducted civil trials.
Yes, I did IRF matters and marriages, and the what you call it, okay, there are so many matters that I dealt with. Divorce matters, I've dealt with liquidation, I've already counted that. I've dealt with, they cannot come up in my mind now.
No, that's
But
all right.
a variety of matters. Yes.
And criminal trials?
Criminal trials, yes, I did.
And you've produced judgments, written judgments.
Come again?
Have you produced any written judgments?
Yes, I think they are about, if my memory serves me well, approximately 33 judgments that I've delivered. And I've got only one which was reserved on the 19th of or 18th of September 2025.
Last month.
That is on the last session that we had for September, for August and September.
Okay. Do you have any reported judgments?
I have checked with Safri and my secretary that assisted me in Durban. I think I counted about 9 or 12, somewhere there, that are on Safri. Yes.
All right. All right. I'll hand over to Judge President Boyolot to put questions to you and the rest of the commissioners, of course. JP?
Thank you, CJ. Good morning, Mr. Gwagwa.
Good morning, JP.
Yes. You've acted for about 36 weeks, and I heard you saying to the CJ, it was quite interesting. I just want to know, how did you find the colleagues that I work with? Did they assist you, or how did you find them?
Oh yeah, they were very welcoming, and you always say you get experience from the older colleagues that are there in the field. So it was very cordial and receptive and accommodative. So whatever question that one wants in terms of jurisprudence and just getting to know the the importance of respecting the other colleagues and conducting yourself as a judge, and how to approach matters. If you have difficulties, you approach them, guide you. So I did find it very welcoming, and it assisted me to adjust and then to understand the importance of holding that important office of being a judge, because once you take an oath, you become a judge. We are no longer taken as AJ. You take an office, you uphold the law, you uphold justice. You just apply yourself, in a good way. So yeah, it was quite interesting.
Yes. And you said you sat in appeals and you were a scribe in some. How were the comments that you received from the presiders? Because I would imagine the presiders would have been sitting judges. What were the comments with regard to your draft judgments, to your judgments?
Oh yeah, no, they were very welcoming, and they guided me. So everything was done according to the script, So um, it was very interesting and educative, and it gave me another picture. That if you are in this field, you apply the law according to the book. So yeah, it was good.
Perhaps there on appeals, what would be the difference between a full court and a full bench?
Come again?
What would be the difference between a full court and a full bench?
Appeals, I think it's 2 judges. Full court 3.
Full bench 2?
Full bench, sorry.
Yes.
Yes.
Okay, all right. And your average time for handing down judgments, what has it been?
You could
And what is the longest that you have taken?
1 to 3 months, if you say. Yeah, I think the average, you could say 1 to 3 months.
All right. And one of the comments, I think from the GCP, was that you were not able to efficiently and effectively handle JCM roles. Perhaps you can just explain briefly what the JCM role entails, and what do you say about that comment?
JCM roles are matters that relate to RF matters, that they make an application to have matters ready for trial. So you look at the rules, whether there's compliance with the rules, like your Rule 37, joint minutes, and whether the matter is ready for trial. So you look of the compliance. You can't certify a matter ready for trial when there's non-compliance of Rule 37, there's non-compliance of joint minutes, there's non-compliance of discovery, and so on and so on. So you look at all those things. I think I read the comment and where it says I am shy. Well, shy is another thing. Knowledge of the law is another thing. It doesn't mean that if you don't comment, it means we are not conversant with the jurisprudence of the law. We are not conversant and understanding of what is expected of you.
Well, they say you looked overwhelmed and did not have sufficient grasp of the issues.
I think it's a misconception. The observer or whosoever observed me, I think he only looked at one side, because I queried some of the matters that were not ready for trial. So I did contribute, So it's not that I was just a lame sheep that is sitting there without any contribution. So there was kind of a contribution. So I understand what it means. I've been doing RAF for years, So I understand when matters are ready for trial. I understand when there's non-compliance. I understand the issues that need to be looked at. So I read the papers before. I write my notes, and I comment and tell the practitioners, have you looked at this? Have you looked at that? So I do have an understanding of what is required. So, and I give guidance from that.
Yes. Sorry, just on the reserve judgments, at the time that you submitted your application, you had one.
Yes.
Do you have any outstanding judgment other than the one for September?
That outstanding judgment was delivered on the 1st of September 2025. So it's cleared. It's only one that is outstanding, which was reserved on the 18th of September 2025.
Yes. In section 4 of your application, on that first question, you said you were behind with your bond and rental lease payments. What is the position now?
I've sold my house and it's waiting for registration. Once I receive the proceeds of the sale, I should be able to pay all my debts. So
So you're not coming to the bench for financial security?
no, I'm not bankrupt
Okay. Yes.
at all.
Now, just two issues on points of law. Is a Rule 43 application order appealable?
Or is it?
Is a Rule 43 application order appealable?
No, can't.
Sorry?
No,
It's not,
No,
yes.
it's not, yes.
And in a matter that is urgent, and you find that the matter lacks urgency, what is the appropriate order to grant?
Okay, you look at, that is Rule 60, subsection 12. You look at the urgency, whether the matter is urgent. You look at the requirements, because now the
No, the question, I know the question is, what is the appropriate order you grant when you have found that it is not urgent?
if it's not urgent,
Yes.
strike it off
Yes,
with cost.
yes. All right,
Don't forget cost.
all right. And then,
Punitive cost sometimes.
yes, just on the matter, on the judgment that you attached, the first judgment, I think it involves the Minister of Police. The order you grant there is in terms of the notice of motion. Why did you not itemize what the notice of motion says? Because if somebody now is reading your judgment, you want them to have the notice of motion. Why didn't you just itemize what is the order that you are granting?
I think it was access to information. What I wanted to highlight was the rule of law, was to uphold the rule of law.
No, I understand.
Yes.
My question is, the order you are granting, it says you grant an order in terms of the notice of motion.
Yes.
Yes. So I'm saying, why didn't you say, I'm granting the order for access to information instead of saying notice of motion? Because you now want the reader to have access to the notice of motion
Yes.
before determining exactly what the order is.
Okay, maybe I might have not done, correctly, if I may say. Yeah.
There's room for improvement in
Yes,
terms
there-
of the style.
Yes, there's room for improvement. Yes.
All right. And then the complaint by Mr. Matenjwa, I'm not going to get into much detail about it, but I just want to ask this question. Is it likely that you might be called as a witness in that matter?
No. There is-
Why do you say no?
Okay, I was in the panel for Shatuza Water. As a presiding officer, I was appointed. So in his case, and there was an AG report that came from the AG that consequences must follow, in investigations and consequences. So my recommendation was that because he was on a final written warning, so I recommended that he must be dismissed. I think he was disgruntled by that decision. So there's nothing pending against me. I've not been arrested. I'm not appearing in the court. There's just absolutely nothing that is pending.
So the case I'm referring to is the case before the High Court that involves both Mr. Duze and Mr. Mhlanga, and the trial has not commenced.
I have not been approached, and I don't think I will be approached.
Yes.
For the last 4 years, 5 years?
Well, it has not commenced for one reason or the other. So,
Well,
yeah.
I don't have any evidence to give. I was just a consultant.
Yeah.
So
All right.
it's unlikely.
Okay. Thank you, CJ. That's all for now, CJ. If I might be allowed, if need around, to ask other follow-up questions. But that's
Of
all
course.
for now.
Thank you, Shaky. Premier?
Thank you, CJ. No, I'm covered.
Got to welcome you formally. It's good to have you back with us again. Welcome. Minister?
Thank you very much, CJ. Good morning, Mr. Gwagwa.
Good morning, Minister. How are you?
I'm well and you.
I'm blessed.
Yes. Let me follow up on what JP raised with you. If you look at the comments by GCB, they do pick up two cases on the roll. Legal Practice Council versus MS Gwagwa. Are you able to explain those for us?
All right. When I read that question, it was in a present form. I think 4 years ago, 2021, 19 February, I was suspended by LPC. The reason why the reason of my suspension is because there was a letter that was written to me and I could not respond because of time constraint. Then the LPC took a decision to suspend me pending the investigations. So subsequent to that, I made an urgent application to uplift that suspension, which resulted into a negotiation between my legal team and the LPC. Then I went and I attended a inspection committee which recommended the upliftment of my suspension in September 2021, somewhere there. So eventually there was a recommendation of the upliftment of the suspension. So the question, I understood the question in the present form, hence I answered in that form.
Maybe just take us to what was the matter about, because Legal Practice Council deals with conduct of practitioners.
Okay, it was
Now, if you have previous case of misconduct, whether the suspension was lifted, but what was LPC concerned about when they wrote you a letter?
it wasn't a misconduct per se. It was non-responsive to the letter that was addressed to me. So hence the LPC took a decision to suspend me. The complaint was,
What's the letter about?
yes, I'm getting there. The complaint was pertaining to the delay of finalizing the estate of late Blias Mabaso. So the complainant was saying, I'm not paying the rates, I'm not showing them the LNT account, which was false. That was the main complaint. So it wasn't about embezzlement of funds, no. It was just, those petty issues which were eventually addressed when the committee sat. They found that there was. By the way, let me also hasten to mention that that LNT account was accepted by the master of the High Court. Hence, I made an application to uplift the suspension. So it was about, not informing the family of the deceased, which was not correct. I'm not sure whether I've answered your question.
You have, and I'll go on with it. The family complained because they said that you had not informed them, meaning that you were not diligent in your work. That's what they were alleging. That because of interaction, because if you're doing your work, corresponding with the family would be important as a legal representative. That's what I'm trying to ascertain.
No, you see.
Was it?
No, it's not correct. There were kids that were at school where I normally pay school fees, and they were kept updated of all the events. They came to my office time and again, and I showed them. It's just, you cannot control a person, and if one wishes to lay a complaint, everyone is at liberty to do so. So hence the master accepted the what you call the LNT account. So, and then one asked what was the complaint about, So there was a consultation with the Mabaso family. My office is always free. I mean, it's always open for consultation and information. I think that woman was just disgruntled, So we did not see eye to eye. So you know they
This
always-
was the widow, the
Come-
woman you are referring to.
Come again?
Is it the widow? Who is this woman? You're saying that woman was disgruntled. Who is the woman?
Yo, I just forgot the name.
What is the status of the woman within the whole thing?
Status of the woman.
Of the woman. You spoke about children, you were paying for the children.
Yes.
Now I'm assuming when you say the woman, I'm assuming it's the mother of the children.
No, it's the brother of the deceased. Sorry, so it's a sister of the deceased. Sorry, point of correction.
Sorry?
It's a sister of the deceased.
It's the sister of the deceased
Yes,
that
that-
complained against you.
Yes.
That wrote that letter.
Yes.
Mr. Gwagwa, the reason why I'm drilling into the matter, it also goes to what JP was raising, because for me, it's paying attention to detail of your work and being diligent. If they are saying that you were saying that it's an observation of a person in the court with the comment that the JP just asked you about earlier on, about I want to go back to it, because I want to link that between that and this area, and also how you're responding in terms of, because if you have a client, perhaps one would want you to say, this is a client, is disgruntled, I've addressed it in this manner. Now you're saying it's this woman. Yeah, but I'll leave it into that. The issue of JCM in terms of observation, because for me, then it becomes a pattern of communication, being able to articulate, engage, and it goes to the issues of interpersonal skills. Whether you do think that there's a concern around that, in your ability to be able to communicate properly, to interact properly, either with colleagues or with clients. Maybe that will be my last one.
Okay, must I comment? Must I answer?
Yes, please.
Oh no. Like I said, the observation of a person cannot be conclusive. It's an observation that needs me to respond. And to add to my submission, I did not receive any complaint of my inability to articulate myself in terms of jurisprudence, in terms of understanding the JCM, in terms of knowledge. Like I said, my experience in RF matters dates back from, say, when I opened my office 25 years ago. So you look into that. I know RF. I've done, I've done it from, from the beginning. From when I say beginning, issuing of letter of demand, summons, and pleadings and so on. So I understand what is needed when you are sitting there doing the JCM. I understand the jurisprudence. I understand the non-compliance. I understand, the rule of law. So I could interact with the legal practitioners and advise them that, look, you have not complied with section so and so, so please comply. There are no joint minutes here. There's no pre-trial conference. You can't ask for trial when there is non-compliance. So I understand the logistics of what is required of a presiding officer, if I may say. So it's just one of those complaints, But like I said, there was no complaint raised by any practitioner that I'm not satisfied with this acting judge. He does not know the jurisprudence or what. It's just an observation. Because if you look at the comments, they say I'm shy. Shy meaning we are not knowledgeable in law. No,
Thank you, CJ.
JP, that is.
Thank you, CJ. My name is Gwagwa.
Morning, Commissioner.
Yeah.
You place me in a difficult position to understand this issue with the Legal Practice Council. You say the suspension related to what?
I said there was a recommendation by legal counsel
Recommendation
to suspend.
to suspend.
Yes,
You were never suspended.
I was suspended.
But then it's not a recommendation. There was a suspension.
Yes, there was a suspension.
Yes. What was it about?
They were saying I was okay. You know, they first made a report that they had to guard against the estate. That there is a suspicion that there is an embezzlement of funds. There is a suspicion of not handling the estate in a correct way. You know, they write all those things. But
I don't know. That's why I'm asking. What
yes,
was it about?
I'm trying to remember because I've not read it for 4 years. But it was about a suspicion, not a report with tangible evidence. It was based on suspicion,
Who had a suspicion?
LPC.
The LPC.
Yes.
Was it not pursuant to a complaint which was lodged against you?
It was pursuant to a complaint, yes, because like I said, the reason why they took a decision to suspend is because I did not respond to the first letter that was written to me
By
LPC to respond to the complaint. I did not respond to the complaint, so that is why they deemed it fit that they should make an application to the High Court for my suspension. But remember, the suspension was based on, should I say, delay of finalizing the estate. But all of that was cured by the master of the High Court, who accepted the account, the LND account.
failure to respond to correspondence as an attorney's misconduct. Are you aware?
Come again?
Failure to respond to correspondence as a practicing attorney is misconduct.
Yes.
You are aware?
Yes.
It's not a suspicion.
Yes, I'm aware.
Yes. There are time frames within which you must finalize the administration of an estate, a deceased estate,
Yes.
in terms of the Act.
Yes.
And failure to do so also is misconduct.
Yes.
Yes. And then there was that litigation against you. You say it was settled.
There was litigation. There was a suspension, and then I did an urgent application, subsequent to that suspension. It was done within, say, 6 months or so. So if you combine, the suspension was in February, and then in September was an application, before September, and say about June, July, there was an application to uplift that suspension. And then there was an agreement that I must attend the inspection committee, which recommended the upliftment of the suspension in September, or early September, yeah.
But the acceptance of the liquidation and distribution account by the master does not cure the misconduct which had already been committed.
Well, when you say misconduct, okay, under normal circumstances, the estate must be winded up within 6 months. If you don't meet the target, it doesn't necessarily mean that is the misconduct. That's your understanding. So I have a different view, because there might be some challenges that contribute to the delay of the estate. So it's not necessarily a misconduct, but it's just a delay that must be explained.
But then you must get an extension of time from the master. You apply for that.
Yes, I did.
Yes, which you did not do in this instance, as I understand.
No, I visited the master, because from time to time I had to visit the master and attend to the queries that were raised by the master, and those queries were cured, and then hence the master accepted the LND account, which prompted me to make an urgent application that, look, I have now complied with the outstanding issues that were raised by the master. So the account was accepted. Hence, I had to do this urgent application.
Yeah. One of the difficult issues is that your failure to disclose this crucial information has led to you and I now debating on this matter. Something this should not happen.
Well, if one read the question, you see, in a criminal court, you are always asked, the accused is always asked, any previous conviction, and then he discloses it. Any pending cases. The question is general, and if I may add, I think during June or May, I applied for a certificate of good standing at LPC, and it was issued, which means there is no pending issues of misconduct. How can the LPC issue a certificate of good standing? Now, I have to think 4 years back and disclose and explain what happened. My mind was on the present, so I couldn't mention something that happened 5 years ago. So unfortunately, my thinking, my understanding was in the present. Hence, I answered in that fashion.
But it doesn't say in the present, it says, has any legal professional body ever found you guilty of any
But now,
unprofessional or disgraceful conduct?
But I was not found guilty. Remember the inspection committee recommended the upliftment. I was not called before a disciplinary hearing and found guilty of misconduct. No. So it's a different thing. It's the way you understand it. The only thing that happened is the suspension. Suspension doesn't mean that you are guilty.
Okay.
Suspension means you are being investigated. You are innocent until proven guilty. I don't have any misconduct from LPC, not a single.
Yeah. You see, with professional conduct, it doesn't have to be presumption of innocence, as I understand it, but how you conduct yourself. That's the standard in a criminal court, like we were now mentioning criminal case. But for the integrity and conduct, I don't think so, but you are entitled to your opinion. Thank you, Chief Justice.
Thank you, JP. Professor Marumachai?
CJ, may I just ask a follow-up on JP Tlaleti's question?
Yes.
Yes, just on this issue of suspension, I assume that notice was given to you of the proceedings by the LPC.
Yes,
Did you defend the application?
it was defended.
And the judge granted the order despite you?
In fact, I even acquired the services of an advocate to ask for a postponement
Why did you ask for postponement?
in order to file the accepted LND account. So that was refused.
But had you filed your answering affidavit
Yes, I did. Yes.
and the matter was argued and the judge granted a suspension order?
Yes.
All right, thank you. Thank you, CJ.
Prof?
Thank you, CJ. Good morning, Mr. Gwagwa. I'm here.
Oh, sorry. Yes.
Yes. Can I please refer you to page 10, typed 10 of your bundle? I think on our side is page 14 of the paginated.
Is it on this one? This one?
I would not know. I would think perhaps the huge one, it will be page 14, I would think. Then the small one will be page 10, yes.
So, is it
But
this
anyway,
one?
just to not waste time, there is a case that appears there. It is a Rule 43 case. You remember that case that you did at Peter Marisburg?
Rule 43.
It is, I'm not sure if I'm pronouncing the word correctly, moon versus moon or man versus man. It was delivered it was heard on the 2nd of August and delivered on the 12th of November 2024.
Yes.
You remember that case?
Yes, I remember.
Yes. I had a chance to read that case. And I just want to raise certain things with you just to get your response.
Yes.
First and foremost, when one looks at the Pietermaritzburg Code, there is an issue about prolixity in Rule 43 applications. And the most recent judgment in that court seems to suggest that when the issue of prolixity seems to appear, the matter must be struck off the roll. But it doesn't appear as if you have a problem of that issue in this case. What I want to ask you about is, when one considers a Rule 43 application, what is the actual test that must be used to determine whether the interim maintenance sought and the contribution to legal costs sought are warranted under the circumstances? And I'm asking you this question because it doesn't seem to me, when I'm reading the judgment, that you actually undertook the exercise of determining the respective earnings of the parties. When I read it, paragraph 5, 15, and 10, it seems to me that you just accepted the version of the applicant, even though both parties were business people. I could not really understand your approach in that case. What is the actual test when you are considering a Rule 43 application? Particularly, I'm concerned with maintenance, not so much about legal contribution.
I think in that case, if my memory serves me well, it was about I think two issues. One, it was about the maintenance as well as the custody. You know. Yes. You wanted to.
What I'm asking is, in fact, it was about maintenance and contribution to costs.
Yes.
Those are the two issues before the court. But I'm more concerned about the maintenance part. I want to understand your understanding of the route that you need to take to say this party must pay interim maintenance to this one pending the finalization of the divorce. That's just the test. I want to understand the test part.
I think it's about the affordability. You know, first you have to check whether you have to check whether the should I say the respondent is earning money. Sorry, is salaried or is gainfully employed. That's you have to, because you can't grant an order when the respondent is not gainfully employed. We have to check that, you know, because there might be an application, and then once you assess that the respondent is not gainfully employed, what's the point of granting an order that won't serve any purpose? So you have to check that first. So two, you have to check the amount that is claimed against the respondent. You know, so you have to calculate whether does the respondent, or should I say, is the respondent able to pay that amount? Then you have to make some calculations, because in the application there should be some pay slip, you know, that will guide you in determining the amount that is claimed. If I remember, the respondent was gainfully employed. He was getting enough salary or money to maintain. So my understanding was to look into that first, and then see to it that is the amount of money available, because there were scenarios that were put by both parties, calculations that were made. So in order to give an understanding and a determination by the court to decide whether is that amount available, is it appropriate. Even the respondent considered that he's employed, and how much is he earning. So there was, a clear picture for the court to make a decision.
Sorry, CJ, can I just do one follow-up?
Bear in mind that we have 6 other candidates to
Yes, just a
interview
small
today
one.
still.
And I apologize. I struggle with that explanation because one, in the judgment, you state that in paragraph 26 that you state that there's no pay slip in this matter. There's no pay slip in this matter in that paragraph. But what I've struggled with is because you need to go and try to understand both the means and the expenses of the person before you actually make them pay maintenance. And you look at the other person's means and needs. But it doesn't seem like that exercise you have engaged with in this case. But I will leave it there. Okay. Thank you very much, CJ.
Sorry, Chief
Is
Justice.
there follow-up?
Yes.
Okay.
Maybe not. Let me not. It's actually not a follow-up, but it's a follow-up to the other questions.
Okay, put them hastily, Commissioner Nkoito.
Thank you. Mr. Gwagwa, can you just explain to us whether you think it's appropriate to refer to Mrs. Mabaso as that woman who was disgruntled?
Maybe for lack of a better word, because I've forgotten her name. So my apologies if I put it in a wrong way. So my apologies.
No, but what do you mean if you put it in a wrong way? I mean, this was your former client that entrusted you with a very sensitive family matter of an estate. And when the minister is asking you, you say, well, that woman is disgruntled. When I ask you, you say, well, if you were wrong, then you apologize. I don't really understand that. And one of the things we need to evaluate is judicial temperament and demeanor.
I just forgot the name, Commissioner. I should have mentioned her by her name. So my sincere apology if I've failed to mention her name. I have respect for women, so so my apologies if I've not addressed it correctly.
Well, at the risk of breaking my own rule that we should try to be, quick about these things. Referring to someone as flippantly as that woman, you could have referred to her even without mentioning her name in a more respectful way.
Yes, no,
Without
my
mentioning her name.
Yes.
Mm.
I accept that. Thank you.
Did you have another follow-up, Commissioner Nkoito? Was that the only issue?
No, Chief Justice, thank you.
Commissioner Mangen?
Thank you, CJ. Good morning, Mr. Gwagwa.
Good morning, Commissioner.
I'm also troubled by the responses that you gave to the questions put to you by the Minister and JP Tlaleti. Depending on your response to my question, I may want to probe it further, but let me ask you this question. Do you appreciate the seriousness of this matter? The seriousness of the finding by the LPC to suspend you pending investigations?
Yes, I know the implication.
If you did, and the GCB had warned you that this is an important matter that the JSC may need to probe you further on, why did you not find it necessary to take the JSC into confidence and make copies of the application and your response to this body?
Eventually, I did that. Hence, I responded to the application that was filed in court. you know. So I answered all the allegations that were leveled against me. So it was not just a matter that was unopposed. It was opposed. So I followed the protocol. I engaged counsel. We replied. You know, we filed every necessary document that was needed. So I complied.
Did you make those copies available to the JSC?
They were not. They were not. You see, there are two issues here. My understanding of question 4 was in the present, so I did not. I only answered the questions that were raised in terms of question. I think question 4. Yeah. But there was a response, or should I say, answering affidavit that was filed in court with regards to that application for suspension.
Thank you. Thanks, CJ. I may have wanted to follow up, but I can leave it at that.
Thank you, Commissioner. Commissioner Shivan?
Thank you, Chief Justice. Mr. Gwagwa, on page 12 of your application form, in question, the answer 9 in point 9.5, the question is, please list any reserved judgment still outstanding and the dates on which judgment was reserved. You mentioned 2 cases there. Am I right? You mentioned Robert Feldegg versus Frederick Wilhelm, and then below that is Gerard versus Warner. And you go on to say that application for sequestration, you put 1 case number, and then the explanation is judgment was reserved on the 14th of March, 2025 at PMB High Court. Draft is completed, still with the researcher. The judge president earlier asked you, is that judgment, is your answer that judgment was delivered on the 1st of September? The sequestration one. I'm just seeking clarity on your answer to the judge president, Oyo Gawati.
There were 2 applications, one for sequestration and the one for liquidation. The one for liquidation was delivered earlier, and then the one for sequestration was delivered on the 1st of September. So both of them were delivered.
So was it 1 case or 2 cases?
2 cases, sorry.
2 separate cases?
Yes, 2 separate cases.
And you say that the 14 March judgment was delivered on 1st of September. Is that what you say?
The one for sequestration, it was delivered on the 1st of September. But the one for liquidation, it was delivered earlier, I think June or July.
But if you take that 14 March date, if you're saying that's delivered, that's a lapse of 5 to 6 months
14th
after the hearing.
14th of March was the date that both judgments were reserved.
But delivered 7 months later, 6 to 7 months later.
Well, March, April, May.
And you said the draft is completed, still with the researcher. What was the research required? The sequestration, as I understand it, if it's sequestration, it's pretty straightforward.
There were 2 voluminous applications. You know, I had to apply my mind. I had to deliver quality judgments. So, you know, I had to spend time doing research and everything. So hence they took longer than expected.
And then my follow-up, my second question is that you said on page 17 of your application, and the judge president, Poyo Dawati, also referred to it, you said you are behind with my bond and rental leases or in arrears. What led to this? You told us earlier that you represent municipalities, and that to me is a very good, solid practice if you said you represent several municipalities. So what led to the financial
I think it's delay
problem?
Delay in getting your what you call payment of invoices. You know, so it leaves a gap. So that is why I had to, you know, put my house on sale so that I can dispose of all the debts. So, you know, sometimes if you invoice and then municipalities, sometimes they don't pay, you know. So they just sit.
So those debts have not yet been settled. Not yet. They're in the process of being settled. Am I correct?
No, some of them have been settled now. So I've settled some of them. So I'm just left with a few.
Thank you. Thank you, Judge Perez.
Commissioner, Dipuzon.
Thank you, CJ. Sorry. Thank you, Chief Justice. Morning, Mr. Gwagwa.
Morning, Commissioner.
My question relates to page 11, the paginated number is number 11, but the printed number is number 7.
Page 11.
Yeah, 11, the handwritten one. Are you there?
Is it on the bigger banker?
Yes, this document. Page 11.
Yes, page 11. I'm on page
Paragraph
11.
6.5.
Oh, 6.5, yes.
Yes.
At the top there.
The CJ asked you about the judgment, and then you said that the reported judgment, you said that you asked your secretary to check if there are any reported judgment, and then you said you have since discovered that there are about 9 to 12 judgments that are reported.
Yes, correct.
On Safely. Is that correct?
Yes, that's correct.
But now, in paragraph 6.5 of the questionnaire, you said that there are none.
Okay, I think at the time of filling this form, I had not inquired from my assistant in Devon as to whether are there any reported judgments at Safri. So that is why I said none.
But
however, I discovered later that there were about 9 or 12. So, but at the time of completing the form, I did not inquire as to whether are there any reported judgments that are reported at Safri.
Sure.
So that is why the answer is none.
But do you understand that it's something that you should have, before you completed the form, it's something that you should have investigated and then complete the form?
I understand it very well, yes.
So in that respect, the form that is before us is incomplete. Do you agree with me?
Well, you may say so, yes.
Okay, thank you. Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good morning, Mr. Gwagwa.
Morning, Commissioner.
As I understood your explanation, Mr. Gwagwa, as to why you haven't disclosed the application to suspend and the order granted by the High Court suspending you. The reason you didn't disclose that in your form is because of the way in which question 3 of section 4 of the form is formulated.
Yes.
You say that it's referring to present disciplinary proceedings.
That's how I understood it. Yes.
Right. Can I ask you to look at question 1 of section 4?
Question 1, section 4.
And that's you'll find at paginated page 17.
17. Yes, question 1.
So question 1 says, are there any circumstances, financial or otherwise, known to you which may cause you embarrassment in undertaking the office of a judge? Did you not think that an order suspending you from practice as an attorney was a relevant factor to disclose in section 1?
Not at all.
In question 1?
Not at all, according to my interpretation of this question.
And if you look at the last question in section 4, question 5.
Question 5.
Is there any other relevant matter which you should bring to the attention of the Commission?
Yes.
So you didn't think that an order of the High Court suspending you from practice is a matter which you ought to have brought to the attention of the Commission?
Not at all. You see, like I said, I made an example of, in a criminal court where you are the accused is asked about the previous convictions or any pending cases. See here, it does not come close to events that transpired 5 years ago. So it depends on my interpretation. So the only thing that I thought is about, oh, I'm in areas for this and that, then I had to bring it up, So I had to show honesty in that this is what I can remember. But anything other than that, unfortunately, I could not understand it in a past form, if I may say.
So an order of the court suspending you for professional misconduct that you don't see as relevant.
But the question did not say any suspension by LPC in the last 5 years. It does not say so. So now, how should one understand the questioning? It depends how you interpret the question. It just depends how you understand, your understanding, and then you answer accordingly. It's not a malice to understand it in a different way. But in any event, I did disclose it and explained that these are the events that transpired then.
And you disclosed it after it had been raised by the GCB.
Come again, Commissioner?
After it had been raised by the GCB.
Yes, I had to answer.
I'd like to take you to one of your judgments. It's the judgment of Man Energy Solutions Middle East.
Oh yeah, that was the
that?
application for rescission.
It was an application to amend the summons.
For amendment of some, yes.
Yes. And what the applicant wanted to do was to include the words, the letters FZE,
Yes.
Free Zone Enterprise.
Yes, I remember.
At the end of the applicant's, of the claimant's, the plaintiff's name. Do you recall that?
Yes.
And the defense raised, the opposition raised to the application to amend was that it would change the nature of the legal entity before you.
Yes.
Because before that it was LLC, and if you add FZE to the end of it, it will change the nature of the legal enterprise.
Yes.
And so what you were actually dealing with was a substitution
Yes.
of plaintiffs rather than a pure application for leave to amend.
Yes.
Now, when you considered the application, you find that there is no prejudice to the defendant. And you don't at all deal with this central opposition, which was that in effect, what the plaintiff is looking for is a substitution of entities rather than an amendment of the summons and particulars of claim.
I think I did touch base on that issue, because the question was whether, if amendment is granted, is there any prejudice that will affect the change of the company as a whole? I think I did revisit that aspect.
You're correct, Mr. Gwagwa, you deal with prejudice. I'm putting a separate issue to you. I'm saying to you that what the opposition to the amendment was that in effect what the plaintiff was seeking was a substitution of entities. Because if you added FZE to an LLC, it became a different legal entity. And for that reason, they were opposing the amendment. That is not dealt with at all in your judgment.
That was the argument by the respondent, and I had to address all of that, because I think it is addressed in my judgment, that issue.
Not in my reading of your judgment, but I'll leave it there. Mr. Gwagwa, just a last issue. You'll know that on the 9th of August, 2025, the judiciary adopted its sexual harassment policy.
Yes.
Are you aware of that?
Yes, I'm aware.
And have you been through the sexual harassment policy?
I know about the sexual harassment document, and I'm quite conversant with it, but I haven't read the recent amendment, but I'm quite conversant with the previous one.
Sorry, was the previous?
With the previous act, which deals with sexual harassment.
I'm sorry, I'm not following you.
I'm quite conversant with the previous sexual harassment act that deals, the previous sexual harassment act. I'm quite conversant with it, but I haven't read the recent amendment act.
Which previous sexual harassment act are you referring to, Mr. Gwagwa?
The one that is existing currently.
Is that the new policy?
The previous policy that existed before.
Thank you, Mr. Gwagwa. Thank you, Chief Justice.
Commissioner Kotso,
In the interest of time, I will forego my question.
you covered. Inkos Nonkonyane.
Thank you, Chief Justice. Good morning to fellow commissioners. Good morning, Mr. Gwagwa.
Good morning, Commissioner.
My question actually is a follow-up to the question that was posed by the JP of the province initially around the allegations from Mr. Zet Mtenjwa.
Oh, yes.
Matenjwa, rather, sorry. I leave the portion she brought to your attention. Mr. Matenjwa further alleges, that's why I'm inviting you for your comment,
Yes.
that you benefited from the 500,000 that was surreptitiously dispersed by Mr. Duze, accused number 8, to the attorneys, which means your firm of attorneys, I assume. But what troubles me, it says, based on the pending criminal prosecutions, Mr. Matenjwa implores the JSC not to consider your candidature for appointment, as that would bring the name and stature of the judiciary into disrepute.
Yes.
I'm merely inviting your comment
Okay.
in that allegation.
All right. First and foremost, he says he opened up a criminal case at Richards Bay, and then he put the case number there. I think there is a paragraph where he says Mr. Gwagwa was not arrested. It should have ended there. So there is no pending case against Mr. Gwagwa, that is myself. There is no investigation pending. I'm not attending any criminal court. I'm not being investigated. I am a free citizen, who aspires to live and make a living. So I think Mr. Matenjwa is grieved or was grieved by the outcome of the recommendation that I made. So he wanted to find something, to hold me at ransom. I'm not attending court. I'm not being investigated. There's nothing pending for 4 years now. In fact, even in future, there's nothing. So the notion that I benefited from the amount that he alleges, he's just putting everything on the table just to derail and confuse the JSC so that there might be something, that the JSC must consider. There's nothing pending. So I'm not even under the concept innocent until proven guilty. There's nothing. So it's just I would say it's jealousy. It's, I would say so. So he just wants to derail, and confuse the JSC. And, that's what I can answer.
Thank you, CJ.
Commissioner Hassan.
Thank you, CJ. I want to follow up, Mr. Gwagwa, on these objections. Commissioner Hassan over here. The objection claims that you later appeared as a witness for one of the accused, I think it's a Mr. Mhlanga, in a CCMA dispute. Do you accept, Mr. Gwagwa, that this could create a perception of potential bias or perhaps even a conflict of interest? In hindsight, do you think it was appropriate for someone who was exercising quasi-judicial functions to go ahead and appear as a witness there?
Okay. See, ordinarily, if you preside over a hearing, any institution sometimes call you to confirm the contents of your recommendation. So that was basically for me to confirm the contents of my recommendation. It wasn't anything else but to confirm that I was the presiding officer, I recommended the sanction against whosoever it is. It's only basically on the procedure side as well as the substance. It's not beyond that.
Okay, and then the objection also says one more element that I think it's important for you to respond to.
Yes.
It says that you did chair a number of disciplinary hearings as part of the panel, and according to the objection, they were used, these disciplinary hearings were used as part of a pattern to target municipal employees who were whistleblowing corruption. So I'm interested to see how you respond to that first, and we also need to understand whether those hearings, or how did you ensure rather that those hearings complied with those natural principles of natural justice and how they were free from improper influence. Effectively, what we need to understand is, or let me allow you to respond first before I do the follow-up. Thank you.
All right. I have always subscribed to a notion of impartiality. Whenever I am appointed to preside over any hearing, I always exercise a notion of exercising fairness, without fear or favor. So I've been guided by the principles or ethics of maintaining the profession and the integrity of the profession. So I understand it very well what it means. So I've not deviated from it even today. So I understand how to be impartial. So the second question is about whether I was used to abuse or implement a notion of should I say, siding with the employer in whatever dirty work that they were doing. No. My principles are based on fairness. They are based on, fairness, if I may say. So I cannot be used otherwise. It's not me.
Final question, CJ. Apologies, it's part of that follow-up. Mr. Gwagwa, even where there was no misconduct that's been proven, do you acknowledge that proximity to allegations of municipal corruption could potentially erode public confidence in the judiciary? And how would you reassure the public that your conduct has consistently met that constitutional or even professional standards, especially given that you are requesting or applying to ultimately come to the bench?
Okay. Can you just repeat your question?
So how would you, well, firstly, do you acknowledge that the proximity to these allegations of municipal corruption, etc., could erode the public confidence in the judiciary? But we're also interested to know how you would reassure the public that your conduct has consistently met constitutional and professional standards.
I understand the principle of, the principle of fairness, maintaining the integrity as a judicial officer in whatever form. I understand what it means to be entrusted to preside either in the High Court or quasi-judicial inquiry. I understand the principle to uphold the law without fear or favor. I understand what it means to be trusted and what it means to maintain and apply those principles of fairness without fear or favor, without prejudice. I understand it very well, and the moment you are appointed, you are entrusted. So you should adhere to certain principles. The rules of natural justice must be adhered to, and must be seen to the public that indeed you can be trusted. I am against corruption. It is not part of my belief. So anyone who is entrusted or who is a public figure or entrusted with duties and functions that will be seen in the public, it should show signs of being trustworthy and apply those principles without fear or favor. So I understand very well. Thank you.
Thank you, Mr. Gwagwa. You're excused.
Oh, thank you.